And Misty, so Robert Costello, what is it telling you when this line of questioning is about him and their relationship?
Yeah, when I've been listening, when we were reading this testimony, I'm thinking to myself, is the defense going to call Costello? And is a lot of eliciting this testimony laying that foundation for the jury to understand the relationship between Michael Cohen and Costello, who has publicly said that he has emails, texts, written communications that directly refute what Michael Cohen has said on the stand. So is that the next step for the defense? Will they call him as a witness? I've always said he was kind of a wild card in this case. Would he actually be called? Because I suppose the idea would be to corroborate some of what the defense is trying to get out there, that a lot of what Michael Cohen has said isn't necessarily true, and is there something more dispositive than just kind of poking holes in his credibility?
Yeah, so Anna, if they're going to go there to make the jury not feel like this is just a sideshow, I mean, the fact that they're bringing all this up, does this mean the defense really has to deliver? Because if I'm the jury, I'm thinking, okay, where is he going with this? What are you building up to, right?
Yeah, I mean, I think that's really the issue is there are so many sideshows. And so on the one hand, that can be helpful to the defense, right? Come, look over here and don't look here. That's something that we've all done, I think, as defense attorneys. And so that can be effective. The problem here is that we're just going on all these avenues. And I think at a certain point, the jury is going to be like, where are we actually going? What is the defense? What should I be looking at here? And so with these people who aren't here but keep getting talked about, right? We know this isn't the only person who has been discussed a lot, but it hasn't actually testified. I really think this comes down to the jury instructions. We were just talking about that a little bit, but to me, this case is going to be won or lost on the jury instructions, what the judge decides, how he's going to instruct the jury to consider witnesses who have not testified. That's going to be really crucial. Are there inferences that the jurors may draw, or are they told you just may not consider it whatsoever?
Can you give some examples of that then, in terms of like what he could say as it relates to this case?
Well, so part of what the judge has to determine is whether or not there can be an adverse inference drawn, meaning if one of the sides decides not to call a witness.
Like Alan Weisselberg, for example.
Could the judge say to the jury, you may assume that the prosecutor could have called them, that he could have testified in their favor, and they chose not to, and therefore you can draw an adverse inference against them. It's my position that the judge cannot do that in this case, and the reason is because part of that instruction is that the party, the side who is going to call them, must know that they could have testified favorably. And in this case, we don't know how he would testify. And so I don't think the judge is able to say that he could testify favorably for either side, in which case that's why I say this really comes down to the instructions, because the judge is going to have to modify that instruction and decide how he wants the jury to look at these sort of empty seats.
And so, Danny, never been more important to hear those judge instructions. But as a defense attorney, what are you doing if you don't plan to bring Robert Costello as a witness, but you spend an hour and a half talking about Robert Costello and his relationship with Cohen?
I think it's likely they will not call Robert Costello as a witness. I still think the best likelihood is that there are no witnesses for the defense.
Really?
Because here's the thing. Let's say you call Robert Costello, and let's say he puts the lie to something Cohen said about his interactions with Robert Costello. How much of the prosecution's case does that actually attack? Do you really want to put on a witness? Because once you do, the burden doesn't shift to the defense, but once you start putting on witnesses, spiritually, the burden kind of shifts in the sense that you must be trying to prove something. So in a case like this,
and it opens up different lines of questioning?
That's the other fear. Listen, the vision, there's this mythological criminal defense attorney who has the big chalk stripes and he's outrageous in court. The reality is most of us are really risk averse. That's why we don't call our clients. That's why I often rest without calling any witnesses, because you don't want to be that cautionary tale in the courthouse. You hear about Steve? Steve called a bunch of witnesses and the prosecution skewered them, and he grasped defeat from the jaws of victory. He had that case won. None of us want to be that. So as a result, we're an industry that is, I think, very risk averse. You don't want to put on witnesses and start shifting the burden to yourself, which it never actually shifts, but it kind of does when you start calling a bunch of witnesses. The move employed by most, and I don't have statistics, but a lot of the time, criminal defense attorneys call no witnesses, and they base their entire argument on that lack of proof beyond a reasonable doubt. It's the safe thing to do. Is it always the right thing to do? I don't know. We really don't know. I think, honestly, I would like to see more defendants called to the stand. I think it might help them, but that would be bucking hundreds of years of then conventional wisdom. And again, you don't want to be that guy who called his client to the stand, and the client was an absolute disaster. There are stories out there. Everyone knows them. Everyone at this table knows them. And the reality is this. The client, individual civilians, even lawyers are not going to be amazing witnesses because the rules are skewed against them. The rules are the questioning attorney gets to ask the questions. You're only there to answer them. And even among us lawyers, very few of us have testified. The only people that testify every day are cops, and they become pretty good at testifying. But even us lawyers, we don't take the stand very often, so we're not very good at it. So, look, the risk-averse approach, call no witnesses, go right to closing argument and say, that's all they got nothing.